Welcome to Education Law, where I share up-to-date court decisions from the perspectives of educational administrators and policymakers. This is episode 37. In this episode, I'll introduce a recent case about a First Amendment retaliation claim involving the Denver public schools. The case centers on a vocal advocate who was barred from his volunteer coaching position and restricted from the school district facilities after his outspoken criticism of the school district officials. This case offers valuable insights for administrators navigating similar challenges. Here is the background of the case. Brandon Pryor, a passionate advocate for educational opportunities, often criticized the Denver public schools and its officials, sometimes using strong, offensive language. His advocacy took many forms. He texted privately with the school district administrators, spoke with officials in person, appeared on local podcasts and news media, posted on social media, attended school board meetings and work groups, and participated in public comment sessions. Pryor frequently called for resignation or termination of certain school officials, accusing them of operational missteps, school funding, cronyism, educational choice, and discrimination. In response, the school district barred him from his volunteer coaching position and restricted his access to school district facilities. Pryor sued the Denver public schools, its superintendent, and its deputy superintendent, alleging First Amendment retaliation. Pryor claimed the school district retaliated against him for his outspoken criticism by removing him from his volunteer coaching position and restricting his access to school district facilities. The district court granted a preliminary injunction in favor of Pryor, preventing the school district from enforcing the restrictions outlined in the Thompson letter and from taking further retaliatory actions against Pryor. The Thompson letter, issued by the school district's general counsel, accused Pryor of abusive, bullying, threatening, and intimidating conduct toward the school district staff. This letter cited many instances over 2 years, including Pryor's criticism of the school district in his text messages, Facebook posts, and statements made in phone calls and a local podcast. The court found that Pryor was likely to win his First Amendment retaliation claim would suffer significant harm without the injunction, and granting the injunction was in the public interest. When the case was appealed, the 10th Circuit Court of Appeals upheld the district court's decision. The court's decision was based on the 5 elements of a public employee's First Amendment retaliation claim. The first element is speech made pursuant to official duties. This element examines whether the speech was part of the employee's job responsibilities. If the speech is within their official duties, it may not be protected under the First Amendment. For example, if a teacher criticizes the curriculum during a staff meeting, not a private backyard barbecue gathering, and the teacher refuses to implement the curriculum, that speech is not protected by the First Amendment. However, if the same teacher writes a letter in their private time using their personal computer and sends it to the newspaper criticizing school board policies, that speech is likely outside their official duties and is protected by the First Amendment. In Pryor's case, his speech included text messages, social media posts on his personal social media account, public comments and appearances on news media and local podcasts, all of which were outside his duties as a volunteer coach. He was speaking as a private citizen, not a public employee. The second element is the speech on the matter of public concern. The speech must address issues of public interest, such as school policies, funding, discrimination, or administrative decisions, rather than personal grievances. For example, an administrator publicly criticizing mismanagement of school funds is addressing a matter of public concern. On the other hand, complaining about a personal promotion or salary issue would not be protected. Pryor's criticisms focused on important public issues like school funding, cronyism, educational choice, and discrimination, making his speech a matter of public concern. The third element is government's interest in efficiency versus employees' free speech. This balance considers whether the government's interest in maintaining an efficient and harmonious workplace outweighs the employee's right to free speech. The government must show that the employee's speech caused or is likely to cause significant disruption. For example, if a teacher's public criticism of school policies leads a significant decline in staff morale, the school district might argue that its interest in maintaining order outweighs the teacher's free speech rights. In Pryor's case, the court found that his speech did not threaten the safety of school district employees, but instead endangered their jobs. Pryor's criticisms included accusations of mismanagement, cronyism, and discriminatory practices within the school district. For example, he publicly called for the resignation or termination of certain school district officials, accusing them of operational failures, and highlighted issues related to school funding and educational inequality. The school district argued that Pryor's speech caused disruption and harm to the work environment. However, the court found that the school district's interest in maintaining an efficient and orderly workplace did not outweigh Pryor's right to free speech. The court emphasized that while the district may have found Pryor's speech offensive or disruptive, the potential disruption was not significant enough to justify restricting his speech. Moreover, the court noted that the school district did not provide sufficient evidence that the Pryor's speech had a detrimental impact on the actual functioning of the school or posed any threat to the safety of its employees. Instead, the court concluded that the district's actions, removing Pryor from his volunteer coaching position and restricting his access to school district facilities, were likely retaliatory measures taken in response to his protected speech. This kind of retaliation is prohibited under the First Amendment because it punishes individuals for exercising their right to speak on matters of public concern. The school district's interest in avoiding criticism and maintaining its reputation did not justify infringing on Pryor's First Amendment rights. The Fourth Amendment is protected speech as a motivating factor for adverse employment action. The employee must demonstrate that their protected speech was a substantial or motivating factor behind the employer's adverse employment action, such as termination, demotion, or other retaliatory measures. For example, if a school district demotes a principal shortly after they publicly criticize the school district's handling of special education programs, it suggests that the adverse employment action was motivated by the protected speech. In Pryor's case, the restrictions imposed on him, such as removing him from his coaching position and restricting his access to facilities, was directly linked to his public criticism of the school district. The fifth element is the same decision absent the protected conduct. The employer must prove that it would have taken the same adverse employment action if the employee had not engaged in the protected speech. This means the school district must show legitimate, non-retaliatory reasons for the action. For example, if a teacher is dismissed for poor performance and the school district can demonstrate a history of documented performance deficiency, it may argue that the dismissal would have occurred regardless of the teacher's public criticism. The court found that the school district failed to show it would have imposed the same restrictions on Pryor without his protected speech, suggesting that the action was retaliatory rather than legitimate administrative decisions. What can educational administrators learn from this case? First and foremost, administrators must understand the boundaries of First Amendment protections and distinguish between disruptive and protected speech. Administrators should recognize that employees and volunteers have the right to speak on matters of public concern, even if their speech is critical of the school district, especially when their speech takes place outside the scope of their official duties. Administrators should ensure that their decisions are not influenced by a desire to avoid criticism or protect their reputation at the expense of free speech rights. Second, administrators should document and address legitimate concerns appropriately. If an employee or volunteer's behavior is genuinely disruptive, administrators should document specific incidents and address them through appropriate channels, such as performance reviews or conflict resolution processes. For example, if a teacher repeatedly arrives late to class or fails to complete required reports, those issues should be documented with specific dates and details. The administrator should then discuss those concerns with the teacher during a performance review, outlining clear expectations and providing an opportunity for the teacher to improve. Administrators should also use conflict resolution processes when necessary. If a volunteer coach is involved in a heated disagreement with other staff members that affects team morale, the school could arrange a mediation session to address the conflict and find a constructive resolution. This approach ensures that the issues are managed fairly and transparently. However, it is important that the administrators avoid using documented concerns as a pretext or excuse for retaliation against protected speech. If a teacher has publicly criticized the school's budget allocations, administrators must not use unrelated performance issues as an excuse or pretext to discipline the teacher for their speech. Any disciplinary action should be based solely on legitimate performance concerns and not influenced by the teacher's protected speech. In Pryor's case, the court found that the school district's actions, removing him from his volunteer coaching position and restricting his access to facilities, were likely retaliatory. Administrators should learn from this example and ensure that their responses to criticism are based on genuine performance issues rather than an attempt to silence dissent. By applying these lessons, educational administrators can better navigate the complexities of free speech rights by respecting constitutional protections while maintaining a functional and respectful work environment.